Good evening, Palante community. I just first and foremost, just to introduce myself, my name is Jesse Gribben. I am a tenants' rights attorney. I've been representing New York City tenants for 20 years now. I work very, very, very closely with Palante and support the critical and vital work that they do protecting the rights and expanding the rights of New York City tenants. I am with the law firm of Himmelstein, Gribben and Joseph LLP. We are a solely tenant side, tenants' rights law firm. The topic tonight is incredibly important, and I want to thank Palante for inviting me to speak with all of you this evening. The topic this evening is how to identify if you are being overcharged. And let me just start by saying a couple of things about overcharges and tenants' rights in the city and why this is so important. The reason is because the landlord can only charge and is only entitled to collect what's called the legal regulated rent. And if a landlord collects rent in excess of what is lawfully allowed, then a tenant is entitled to a correction, if you will, whereby the rent would be reduced to the lawful amount and the tenant would be entitled to damages. And the damages would be the difference, right, between the amount that the tenant was paying and the lawful amount that the landlord was only authorized to collect. And oftentimes that amount is tripled, right? It's called treble damages. So this is not one of those topics where it's hypothetical, right? Or, like an urban myth. Tenants in this city litigate and win rent overcharge awards all the time. We handle them regularly in my firm. In Palante, there's dozens, if not, hundreds of active overcharge cases. Tenants collect tens, sometimes hundreds of thousands of dollars in rent overcharge damages, and this happens with some degree or with some regularity. So it's certainly something to keep in mind and something to be aware of and something to enforce your rights on. So that's why we're bringing this critical topic to everybody this evening. So let me start with one very, very important threshold issue with regards to whether or not you're being overcharged. And that is if you are a rent stabilized or a rent controlled tenant, right? If you are a market rate tenant, right, you can't be overcharged because overcharge is only a construct, right? It's only a term that's applicable to rent regulated tenancies, right? So it can't be a situation where you rent like let's say, for example, in a two-family house and the landlord rents you an apartment and then 3 years or 4 years later, he wants to jack the rent up a lot. And you're like, no, you're over that. It's not overcharged. That's just a landlord being greedy and, the market forces, et cetera. Overcharge only applies, and this is important, if you are a rent stabilized tenant, or a rent controlled tenant. So let me start there. If you are a rent stabilized tenant, right, you usually will have a rent stabilized lease. If you're a rent controlled tenant, you probably know that because either you or your family member has been in that apartment since before 1974. So you've been in that apartment for over 50 years, or your family has. So you sort of would know if you were a rent controlled or rent stabilized tenant, but not always. So I think the first step in an overcharge situation is establishing if you are a rent stabilized tenant, and if you're not, assessing whether you are a rent stabilized tenant, because sometimes that's how the process goes, right? You rent an apartment, you're treated like a market tenant, right? Like as if you don't have any rights. It turns out that the apartment is rent stabilized. And once the apartment is deemed to be rent stabilized, that's when you have a setting of the legal rent and then the overcharge damages that result, right? So critically, becoming a rent stabilized tenant is the threshold, get in the door, um, sort of first step in any sort of analysis about being overcharged. The good thing about status, right, is that you can challenge the deregulation of your apartment no matter when it happened. There's no statute of limitations on a rent status claim. So if the landlord allegedly took the apartment out of rent stabilization 10 years ago, we can challenge that today. If it took the apartment out of rent stabilization 20 years ago, we can challenge that today, and so on and so forth. It's a slightly more nuanced issue with overcharge, right? Slightly different, and we'll talk about that in a second, meaning you can't go back to the beginning of time on overcharge. But you certainly can for status, right? So again, if you're not a regulated tenant, right, meaning you don't have a rent stabilized lease, or you're not being, then the first step in seeing if you're overcharged is assessing whether or not you're rent stabilized, right? And then from there, we can establish if you're being overcharged. All right, so how do you tell? How do you get to the bottom of this? How do you know if indeed your apartment is rent stabilized, if it was improperly taken out of rent stabilization, and therefore there's a potential of overcharge, right? Or if you are a rent stabilized tenant, how do you figure out if the rent that you're being charged is the legal rent, right? That's why we're here this evening. And what that takes is a little bit of due diligence, right? A little bit of digging, a little bit of investigative work by the tenant. And it's work that the tenant can do on her or his own, right? You don't need a lawyer necessarily to begin the digging, right? You don't need an expert, right? Because Palante has folks that could assist in this that aren't lawyers. But you don't need someone with expertise to do the initial investigation. So here's the initial investigation, and the most important factor in establishing whether or not you've been overcharged. It's getting what's called your rent registration history from the DHCR. The DHCR is the Division of Housing and Community Renewal. It's the state agency. DHCR is the state agency that administers the rent stabilization law. And the law says that every owner of a rent stabilized apartment, right, or a building that has rent stabilized apartment, but every rent stabilized apartment in the city has to be registered annually with the DHCR. And the landlord's then therefore lawfully required to file with DHCR a registration every year that lists the tenant and lists the rent. The first year they were required to register was 1984. So presumably for everybody's apartment that's stabilized or was stabilized, there should be some records going back to 1984. And if there's not, that's also important to see. So that's the first step. You can't assess whether or not you've been overcharged unless and until you get the rent registration history from the DHCR. And we're going to put some rent registration history up on the screen in a second. But before I do that, the next question is, okay, well, how do I get my rent registration history from the DHCR? And here's how you do it. If you go to, and we can, in Palante, and Jakari, tell me if I'm wrong, but Palante, we could do it as part of the webinar tonight. We could provide the addresses. There's several locations throughout the city. DHCR's primary headquarters, if you will, is at Gertz Plaza out in Queens. But I believe they have an office in the Manhattan somewhere. I think they might still have one at 125th maybe, or down by me in Lower Manhattan, down by my office. but we can get you the addresses. And if you walk into DHCR with a copy of your lease, right, I would do it. And if you don't have your lease or you don't have a lease, a copy of like a Con Ed bill, something to show that you live in that apartment, they will give you a copy of your rent registration history on the spot. Like you might have to wait 5 or 10 minutes, but they will print out and give you a copy of your rent registration history. Might have to wait a few minutes, but it's a fairly straightforward, simple process. You walk in, you tell them that you're there to get a copy of your rent registration history. You show them the proof of residency in that apartment, and they give you a copy. There's another way to do it as well by submitting a request online, and we can share that link as well so that everybody can do it online. There's like a request that you can make for your rent history online. So that's something that's also an option via email. Okay. All right. And so once you have your rent registration history, that will begin to tell you a whole bunch of different things. So at this point, I'm going to ask Jakari to put I have a couple of examples that we can now use as prompts and we can kind of look at together quickly, and we can take a look and see sort of some of the things that we'd be looking for or what the rent history looks like.
Exactly.
So,
Before you
okay.
say one thing, for those new who have joined, we do have a Q&A open. So if you do have a question that you would like to ask Jesse, please place it there and we will get to it.
Okay, so what we're sharing the screen, right? And what you see at the top is going to be the same sort of form you're going to see for every rent history, right? It's going to have some things on it that will say. So this one, it says the subject premises, and it says apartment 13, 57 Leroy Street, New York, New York, right? That's what it has, right? And it will also have a date, like the request date. So this one we got back in March, right, of 2025 of this year, et cetera, right? So this is what will be printed out. You see at the top of the page, it says the Division of Housing Community Renewal, and you start to see like a key of different, like, explanations of how things are characterized. All right, so we could scroll down, Jakari, to the next page. All right, so now we get into the meat, right, if you will, of the history, right, of this tenant's history. And you take a look, right, and what do we see? Oh, in 1984, right, the apartment was registered, right, and you see right there, in 1984, the apartment's registered as rent stabilized, right? You see the RS where it says apartment status at the top, rent stabilized. And it has the name of the tenant, right? JS Hillbrand, right? Everybody sees that. And you see the rent, the legal regulated rent, $676, right? And you're like, okay, so this is beginning to tell us something. What's it beginning to tell us? Oh, this apartment was rent stabilized at one point, clearly, right? And we know the rent, at least in 1984, was $676. So then what do we see? We see that the same tenants listed, right? And then we see for a couple of years, from 1987 to 89, the landlord didn't bother to send in a registration, right? And then all of a sudden, the landlord sends in a registration for a new tenant, right? For 1994, right, or whatever, and they 1990, but they register it in 94, and they say the rent is $1,000, right? And they continue with that, and they have the names of the tenants. And if you see over here, they list a preferential rent of $900, right? All right, let's keep scrolling down. Okay, and you'll see the same tenant, A. Gordon. So this person, I don't know if it's a man or a woman, right? But he or she lived in the apartment for quite a period of time, right? They've been in the apartment for a very long time, and the rent seems to go up, with like in line with the rent guidelines board increases. A little weird, but it kind of does a little bit. And okay, keep going down, Chikari, right? So look, A. Gordon, wow, living in the apartment for such a long time, right? Wow, all the way up till 2011. So A. Gordon moves into this apartment, way back in 1990, 1990, it seems, 90 or 94, and stays there, for almost 20 years, right? And then leaves in 2011, right? Everybody sees that in 2011, 1391. Okay. And then what's significant here is the landlord then says when A. Gordon left in 2011, right, which is now 14 years ago, at that point, the apartment is no longer rent stabilized. That's what the landlord says here, right? You see the letters PE, and then it says exempt. And the landlord's now saying that the apartment's not stabilized, right? All right, one more screen down, Jakari, thanks. And that's the way it stays till the present day. Okay. And the reason here at the top of this last page is it says high rent vacancy, right? People see that at the top right there. Okay, so this is an example, right? So if this person came to me and said, hey, here's my rent history, Jesse, what do you think? Well, what I would do, the first thing I would do is I would go back to when the apartment was last rent stabilized. So Jakar, just go up one screen, one up, one, yeah, perfect. And I would look when it was last stabilized. Oh, it was last stabilized back in 2011. Ah, and what was the rent? 1391. Well, that's not enough to get it out of rent stabilization. In 2011, in July, the threshold, right, the ability for a landlord to deregulate an apartment was $2,500. There's no more deregulation, by the way, and we'll look at something like that maybe in a second. But it was $2,500. So they're like about $1,100 short of that. So on this one, the landlord would have had to perform a whole lot, $50,000, $60,000 worth of renovations in this apartment in order for the apartment to have been lawfully deregulated. So if this person, like, moves into this apartment, wants to challenge the rent here, the landlord, right? The landlord would have to prove that in 2011 they did $50,000 or $60,000 worth of work in the apartment in order to bring it out of rent regulation. And if they don't have the proof, if they didn't do the work, then this tenancy will be deemed to be rent stabilized, right? And that's exactly sort of the analysis that we do and how we look at it. And there's no sure thing here, right? The landlord very well might have done sufficient work. We don't know. But this would be the challenge, right? That they would have to come forward and they would have to prove it. They would have to prove that they did this work in this apartment back in 2011 or 2012. All right, let's look at the next one. I just want to show you guys a few of these as examples just to kind of get ourselves sort of looking at them. All right, let's scroll down. This is in Brooklyn. It's 94 Milton Street. I mean, these are real, right? And you'll see here, right? 1986, right? Very low rent, $226, right? The same person. Just scroll down, Jakari, right? The rent very low, $300, $400, right? This woman's living here for a long time, $400, $500. Keep going down, Jakari. Rent stabilized, right? The same woman from 19, whatever that was, 86, all the way, keep going. She's still in the apartment, paying very little, right? $800 right now in 2021, right? Keep going. Okay. And then what do they say? In 2023, they say exempt, no more rent stabilized, even though the rent was $881, right? Very low rent. And then they say it's not rent stabilized, substantial rehabilitation. What does substantial rehabilitation mean? It means it's a way for the landlord to take apartments out of rent stabilization, but they have to prove it. And what is substantial rehabilitation? That means that the apartment is essentially abandoned. The building is abandoned, right? Nobody's living there. And then they basically do a gut renovation internally to replace 75% of the building systems, and that would allow them to remove the apartment, right? So if somebody moves into that apartment, 94 Milton Street, I would be telling them, we should challenge this, right? Because unless the landlord can prove that they replaced 75% of the systems in the building, the windows, the boiler, the floors, right, the electrical, essentially gutted out the building and rebuilt it. If they can't prove that, you're going to be rent stabilized tenant, right? So this would be another sort of example, another thing to use. All right, you guys put the last one up. Okay, so another one. This one I think is in Manhattan. It is 430 East 86th Street. Okay, so let's go down. Okay, so again, this one's an interesting one, right? So you start to see they have somebody there in 1985 for 694.89, and then you see what it says here: rent control, right? Not rent stabilized, rent control. And they first tenants they put Joseph Sarah, Ali and A Sarabali. They say rent controlled. RC is rent controlled as opposed to rent stabilized, right? And then you see here, if you keep going down, Kari, right, down, all rent control, keep going, rent control, rent control. Okay, okay, all right. So this one is an interesting one, right? Because in this one, they say it's rent controlled all through obviously, if it's still rent controlled, then it's a regulated tenancy. But on this one, they probably took it out of rent control for some reason at some point. But again, like the others, right? Another example, we would have to, if to challenge this, we would have to hold the landlord to its proof and show the proofs. Okay, so there's one or two more things on these histories I want to show you. Can you scroll down just a tiny bit? I want to see if there's anything on this one. Okay, there's not. So you see at the bottom of the page here where it says apartment services, none found, and then it says building services, laundry room, trash disposal, maintenance services, et cetera, et cetera. If there were other cases, right, a lot of times they'll put down related cases or cases, right, and you'll see that listed on the history. I don't think the others have it either, so I didn't have an example, but it would be on the last page and you would see other cases. And a lot of times what we do, right, when we're doing our due diligence is we get this rent history, what we've been looking at, these examples, but we also then file a request with the DHER, what's called the Freedom of Information Law request, whereby we ask them to give us any and all orders or decisions about that apartment. And sometimes there's what's called a rent reduction order, right? Where somebody would have filed something with the DHCR and the DHCR would have froze the rent way back in the day. And if that happened, that could impact, overcharge, right? And there's certainly something to look at, right? Prior cases, prior orders affecting the building. But you get the rent history, and the rent history is what tells you if those other cases exist. And if you want to be very careful, you just go ahead and you just go ahead and you ask the HER for any and every order or decision that impacts that apartment. Okay, so that's the due diligence that you would do, and that's what you would look for and look to as the initial first step to recognize if you're being overcharged. So with that said, and I said a mouthful, I want to open it up for like questions. And if there's some time, maybe I can come back and sort of talk a little bit about what do you do to pursue a claim if you think you're being overcharged, right? And that's also something very, very important. But for this webinar, the focus I want to sort of make sure we stress and we spend ample time to talk about is how do you identify, right? How do you know? How can you tell? How do you begin to assess whether or not you've been overcharged? So I want to see if there's questions about that before I move on to, well, what do we do once we make the assessment and we think there's something there, right? And we can talk about that, I think, in a few minutes.
Okay, thank you, Jesse. I did put the link to how you can request your rent history in the webinar chat. Also, the number to DHCR's main office is in the chat as well.
Great.
The first question is if an rent stabilized tenant has scree and then gets a rent reduction for decreased services, does the rent get reduced below the scree payable rent?
Great question. So how does SCREE interplay with a rent reduction order? So a rent reduction order will roll back the rent to the rate in effect before the last renewal. The your SCREE benefit usually remains stable, right? Meaning they don't usually adjust. SCREE adjust what they're paying. So in that situation, it's your share, right? Your portion of the rent that would be reduced, not the portion that's being paid by SCREE.
Okay. Thank you. The next question is, can the landlord change the actual move-in date contradicting the lease? For example, lease states move-in date 2018 when I have been living there since 2009. I think he's saying like, can you change it on the rent history? I'm guessing.
I mean, so okay, quick. I mean, so okay, so as far as the rent history, that is a landlord document, right? Let me make that clear, right? The rent history is not like an objective like finding of that's what happened. That's what the landlord is representing to the state is what the reality is and when the apartment, right? So rent histories are often filled with things that are just either wrong or worse, fraud, right? Like that happens all the time. Again, you don't know that initially. It's a starting point, but yes, things on rent histories are totally wrong. As far as a lease, um, you got to be careful. I don't really understand exactly the question, but you got to be careful when you sign a lease that you don't sign a backdated lease, right? Like you don't sign a lease with a start date way before like you actually move in, right? Because then you're on the hook for the rent for that time potentially. So you got to be careful about that.
Okay, thank you, Jesse. Next question. I have a scenario of a rental history with no tenants' names listed, and also that has a combination of mixed occupancy, commercial, temporary rent stabilized, exempt, and high rent vacancy. Would these inconsistencies warrant a challenge to the rental history?
Yes, absolutely. Well, one thing I can say is if the alleged reason that they say in this hypothet in this not hypothet this particular individual's history, if the reason they give for deregulation is what's called high rent vacancy, or which is likely, and there's never been a number registered, never been a tenant registered, never been a rent registered, that is a case that will be deemed to be a stabilized tenancy. You can't deregulate an apartment without ever registering any rent, right? So if this history that we're talking about, this never lists any tenant or rent, that tenancy is almost assuredly going to be a rent stabilized tenancy.
Okay, got it. Uh, I have the next question is I have a combination of rent overcharges, failure to provide lease renewals and lease riders, false statements of state and city agencies, failure to register apartment, multiple years of harassment from the last landlord and the new landlord, illegal short-term rentals, and fraudulent schemes to deregulate buildings. Should I start with a rent overcharge and then show documentation of fraud in order to get an expanded review for full history?
All right. So again, this is a good question, and so the way that the law works, the way that these processes work, is you have to figure out causes of action against the landlord, right? So a claim for rent overcharge, right, is not harassment. A claim for rent overcharge is not a claim that they didn't renew your lease, right? A claim for rent overcharge is not about conditions in your apartment, right? There is no, again, we're tenant folks, meaning, right? So I wish there was some sort of global space where you can present and say, let me show you the entire picture of my tenancy to show you what I've dealt with in order to get proper relief. That just doesn't exist, right? So you have to file claims in appropriate forums for those particular claims, right? Like you can't. So again, like it's not this question. Like you can't. It's not start with the rent history. It's if you think you're being overcharged, you have to pursue that claim by filing a rent overcharge claim. If you think you're being harassed, you have to file a claim in the proper form to allege harassment. They're not the same, and there's no like ombuds global complaint to encompass everything, right? This is very, very important, and so that's something certainly everybody got to be very clear about. Like you have to present claims in a way that they're viable and not just say, here's everything that's wrong with my tenancy and take care of this for me. Like nobody will. You have to file the proper claims in the proper places and that type of thing.
Okay, thank you. The next question is, are J51 required to be listed on DHCR's last page? Or if you have it in MCR order but don't see it on DHCR and have DOF for you that shows J51 existed, does this set back the rent stabilized date for FM date for apartment for fraud?
Yeah. So if a building it's a good question. If a building is receiving a tax benefit, J51, 421G, 421A, like almost assuredly the apartment's going to be rent stabilized during the time that the landlord is receiving the benefit. That should be on a rent history. It should, doesn't always be there, but it's a good question. It's another part of due diligence, right? If your apartment um, is not regulated, you're going to want to check to see if your building is receiving a J51. That's different than the DHER. I would not necessarily count on DHER to provide that. That information is with the Department of Finance. There's a way to look that up. Um, it's a little more complicated and clunky than getting your rent history, but maybe we can endeavor to sort of show that in some way.
Next question comes from Andrea. According to the rent history, my apartment was apparently rent stabilized until 1993. The tenant at that time paid $372. Then the apartment was converted into a condo and exempt. Can that be challenged?
No, that cannot be challenged. If there was a legitimate conversion to cooperative or condominium ownership, that will take the apartment out of rent stabilization, except for the tenant in occupancy at the time of conversion. So if you're living in a rent stabilized apartment and the building converts to a co-op or a condo, you retain your rent stabilized rights, and you and any successor would remain rent stabilized. But once that apartment becomes vacant, it's no longer subject to regulation. That's not one that could be challenged.
Okay, got it. The next question is from, hope I'm saying the name right, Lesbia. Can one find out the rent history for an apartment you do not have a lease for?
Good question. Great question. Very, very difficult, but not impossible. So you would have to file. It's a more arduous process. It's not easy. We've struggled to do it. You would have to file what's called a Freedom of Information Law request, and you'd have to articulate some basis or reason for wanting the history, because they're not. The DHER is a little guarded about that, as far as like they think it's like information or confidential. It's hard for me to understand why, but they're very, very guarded about giving histories to someone other than the resident. It's a challenge. Let me put it that way. It's a challenge.
Okay. Next question is from Javier. New owners took over and they put on the lease renewal moving date 2018, the year they bought the building, when in fact we moved in 2009.
Okay, I mean, so you could cross that out and put that on the lease. That wouldn't impact like status or anything like that. That's just their own whatever nonsense they're doing. But that's not something that raises red flags as far as like your rights or anything of that nature.
Okay, next question is from Anna. How many times can an owner amend the rent history once you start a challenge?
Yeah, so there's no limit on how many times they can amend. I do think that the more they amend, the more it looks suspicious. the more it's likely that there's some sort of fraud, the more it's likely that you're going to prevail in your case. But there is no limit. They can amend the history. They can amend the history 2 times, 3 times, 4 times. They can amend the history.
The next question is from Dr. Tawana. How can I get assistance with reviewing my documents? Do you have contact information?
All right, so Jakari, you'll have to deal with that. That's like I know Palante has legal clinics. I know Palante, if they can, to the extent they can, they would offer services of that nature. But you have to contact Palante and see if you can make an appointment, or for someone to look at your rent history.
Right, correct. So if you do, want to have your documents reviewed or analyzed, we do have housing specialists here that do that. You just have to call us and make an appointment. I'll put our number in the chat, 212-491-2541, and you can give us a call.
And I recommend people do that.
The next question is from Javier. Is refusal to renew rent stabilized lease a form of tenant harassment?
In and of itself, no. But I guess it depends. I mean, it depends, right? So if a tenant receives SCREE, right, or DREE, right, some sort of benefit that requires them to provide a lease, right, as a way to get the benefit, and the landlord refuses to provide that tenant with the lease, so that the tenant then is in jeopardy of losing that benefit, well, then yes, that could probably rise to the level of tenant harassment, right? If you're explicit in letting the landlord know, hey, landlord, if you don't renew my lease, I'm in jeopardy of losing this very important benefit, right? Like from the, people that get HRA benefits, right? That get, that people that get Section 8. These are all critical things, right? So in that regard, I think it could. If it's just nothing else, but I don't have a lease, then no. And the big thing here is if you're a rent stabilized tenant, and I always tell people this, not getting a renewal lease is not a bad thing. It's actually a good thing. The rent stays frozen, right? When the landlord gives you a lease, the rent goes up, right? Unless there's a rent freeze. If they don't give you a lease, they are 100% not able to raise the rent, right? So for a rent stabilized tenant, and then they're also not, if you don't have a lease, they can't sue you for rent in housing court. Doesn't mean you don't owe it, but they can't dispossess you for rent owed when you don't have a lease, right? So leases are landlord documents, right? No landlord says to the tenant, hey, you want to do me a favor? Why don't you draw up a lease and a contract for the apartment and give it to me, and I'll see if the leases are documents that the landlord creates, right? They're all for the landlord documents. So not having a lease is not, for a stabilized tenant, is not in any way harmful. In fact, there's a lot of benefits from not having a lease. So again, it's different if you need the lease to get other benefits, rental assistance, SCREE, DREAM, different. But if it's just, you just want a lease because you feel safer, you're safe anyway without a lease.
Okay, next question is from Danilda. My apartment was rent stabilized in 1984. The rent was $69.90. And then when I moved in 1992, he raised it to $780. Before I moved in, the tenant paid $496.
Yeah, so that sounds like an overcharge. The problem with that one is you've been in the apartment since, for I don't know, 40 years or something, and it's hard to go back and challenge the rent from 40 years ago. It's not difficult to challenge the status, but it's difficult to challenge the rent. I think impossible to go back 40 years and challenge the rent when you've been in the apartment for 40 years. I don't think that that's a viable. I mean, it sounds like it was a rent overcharge. It just sounds like it's too much. The statute of limitations has run too much time.
That was the last question we have.
Okay.
Jesse, you said you wanted to talk about.
Yeah, so let me just do 2 minutes if I can, just to let people know. So this is about the analysis as to whether or not you're whether or not you've been overcharged, right? So the question then becomes, if you think you are, right? Or you want to challenge your rent, how do you do it? And there's three ways to do it. The first would be to file a claim with DHCR, right? File an overcharge claim. That's one way. The second way would be to sue your landlord in state Supreme Court. You bring a case against your landlord in court. You're the plaintiff, they're the defendant. You're the one prosecuting the case. That's another way to do it. And the third way to do it is stop paying rent, sort of trigger, right? Try to compel the landlord to sue you. And then when they sue you for non-payment of rent, that's when you interpose the counterclaim for rent overcharge. So those are the three ways that a tenant can challenge an overcharge in three different forums: in Supreme Court, in Housing Court, or with the DHCR.
Thank you, Jesse. We had another question came in from an anonymous attendee. If you do rent, if you do a rent challenge and DHCR decides in your favor and you get new information, can you challenge the, let me read it one more time, I'm sorry. If you do a rent challenge and DHCR does decide in your favor and you get new information, can you challenge again?
Possibly. I think you would have to speak to somebody, a housing specialist, Palante, or a lawyer, to assess whether or not you could reopen that case. It might be difficult, but it also might be something that could happen.
Okay, thank
you. Yeah. DHCR has a mechanism to do that. They have, it's called like an irregularity in a vital matter, and we've used it sometimes. And sometimes they'll, in the interest of justice, reopen cases and forgive like deadlines and timelines. So I wouldn't like close the door on it being possible to do something with that one.
Mm-hmm. For those who can't see the chat, I did put the number for DHCR's Rent Administration's office. I'm gonna read it out loud. It's 1-833-499-0343, and you can call them to request your rent history. Also, I put Jesse's firm's number there as well, which is 212-349-3000. Then I put Palante's number, which is again 212-491-2541. We just got another question from an anonymous attendee. When does a lawyer get paid by the hour versus percentage? If I file a lawsuit in state Supreme Court, can I include lawyer fees be paid by landlord?
Oh, good question. So if you win a rent overcharge claim, that's an excellent question. If you win a rent overcharge claim, the landlord is obligated to pay the tenant's legal fees no matter what. So if you win an overcharge claim and it's a few dollars, all the legal fees are reimbursed by statute. So legal fees are 100% recoverable anytime you win, right? So if you win an overcharge claim, you can recover legal fees. You have to win though.
Got that. The next question is Lasdia. If an apartment that was illegally destabilized, can the next tenant challenge the new rent?
Oh yes, absolutely. Yes, that's the whole idea. Yes. Yes. Anyone that moves into an apartment, and people should tell their friends, their neighbors, if you move into an apartment in New York City, you should go get your rent history. Like, right, that should be part of what you do within the first few months of moving in. Go get your rent history.
Yeah,
and you can challenge. Yep.
Yeah, and one question that I did not see come through yet, which I know is important. How long does a rent overcharge usually take for DSCR to make their decision?
Yeah, so that's the thing, right? So there's different factors as far as where to litigate, but for DHCR, it will take years with an S at the end, not months, not a year, but years with an S, right? So you're looking at, I would say, maybe 2 years, 2 or 3 years to get a decision from a rent administrator. And then if the landlord or challenges it, another year, year and a half at a par, you're looking 4 or 5 years with DHER. It's one of the reasons why sometimes we stay away from DHER. It's just impossibly long, right? Like, so nothing happens fast. It's an incredibly drawn out process. It takes forever.
And one other question. If do think you're being overcharged, should you still be signing your leases?
Well, if you're a rent stabilized tenant, you have to sign your lease, right? If you get an offer for a renewal lease and you're a rent stabilized tenant, you are lawfully, legally obligated to sign your lease. If you don't, you can get evicted, right? So if you're a stabilized tenant, you get a lease, you sign it. Period. Like, no, there's no one out. That's okay. On the other one though, again, if you're a market tenant, right, treated like a market tenant, and you feel confident in your overcharge claim, then maybe you don't pay, right? Because if you think the landlord owes you 10,000, 20,000, 50,000, $100,000 in overcharges, why would you pay someone that owes you money, right? You don't pay a you're the creditor. You don't pay the debtor, right? Someone that owes you money, you don't keep paying them money. You try to extract what they owe you in kind, which would be, okay, fine, I'm going to sit in this apartment and not pay rent, and whatever, and we'll take it out of whatever it is you owe me, right? That's sort of the thinking. So it's, if you're a stabilized tenant, you have to sign the lease. If you're not a stabilized tenant, it's you got to make a decision.
Okay, thank you. Next question is from Sandra. How do Mitchellama co-ops determine your maintenance fee? And can
Yeah, Mitchell-Lama totally different. Nothing to do with this. The Mitchell-Lama, it's based on, it's a recertification, your income affidavit. It's a different analysis. It has to be based totally on your income. It's not really. It's a totally different structure. It's not. It's not the same. It's nothing. It's nothing. It's nothing. What we've talked about today. There's no rent history. There's no like. There's no. There's not the same type of analysis.
okay. Um, can a tenant, question from Anna, can a tenant who has vacated file a rent overcharge claim if,
Yes, yes. You don't have to be residing in the apartment to file a rent overcharge claim. You can file a rent overcharge claim after you leave and seek damages for the time you lived in the apartment.
okay. Um, a question from Anonymous. My landlord hasn't provided leases or lease riders for several years. I think because they don't want to recalculate and credit for the MCIs from 2016 and 2018, is that considered an overcharge?
No, I don't think that would be considered an overcharge. That's maybe, and they won't be able to get it, but an MCI or whatever, that increases the rent, right? It doesn't reduce the rent. So if they haven't added MCI charges to your rent, that's not an overcharge. That's like potentially their landlord's not collecting the full amount that they could collect, which is good. They don't, if they don't want it, they don't have to take it. But it doesn't. It's not the landlord not taking an MCI increase is not an overcharge. It's the opposite, right? It's
Okay. If a person moved to an apartment that was rent was $950 and the landlord didn't do any repairs or paint the apartment, is the landlord allowed to increase the rent over 20%?
depends on where the apartment is. If it's in like a building that um if it's in like a building with less than 6 units, again, if it's rent stabilized, then the answer is a hard no. If it's rent stabilized, then if it's not rent stabilized, then the landlord can do whatever they want, right? So again, remember, if it's a rent state, if under that fact pattern, if it's a rent stabilized apartment, 100% illegal. If it's not, totally legal.
Benefits slash drawbacks of filing overcharge in different venues.
Oh, yeah, good. Okay, great. So let's do it quick. So the DHER, the benefit is that it's the least like intensive as far as work, right? Meaning the DHER is an agency. You send in your complaint. They prosecute it a little bit, right? Like it's the least expensive if you have a lawyer, right? Because there's the least amount to do. Um, so in that regard, and then it just takes forever and ever and ever and ever, right? So the drawback is it takes forever, and the benefits is that it's the least expensive and the least sort of taxing, if you will. The housing court is probably the best place to do it. The judges there are very familiar with these issues. That's the benefit. It's certainly the fastest. Certainly the fastest would be housing court. The drawback would be you got to get sued, right? You can't sue in housing court for overcharge. Tenants can't sue landlords in housing court except for an HP case for repairs. So you can't sue your landlord in housing court. So you got to wait to be sued. So the downside is now you got sued. Now you're involved in a lawsuit, right? So that's the downside. In Supreme, it's the most expensive. It's our case. It's the tenant's case. It costs money. We're prosecuting the case. We're pushing the case. We're being aggressive, right? We're doing all the litigation. We're pushing, right? We're suing people. It's the most expensive. You spend a lot of money on legal fees. It probably could be it's not as fast as housing court, but it's much faster than DHCR. And then the benefit there would be you control. You're the one suing. You're not being sued. And the downside of the Supreme Court would be the cost. It's the most expensive.
Okay. The final question to end this off will be, I'm a rent stabilized tenant. I've been paying the MCI increases since 2016. I think I'm supposed to get credited since HSTPA
Yes.
changed
Yes.
rules in 2019. They're supposed to recalculate the MCI charges from max 6% to max 2% of the
100%. If that was the question before, I didn't understand it, but now I do. So that would be 100% be an overcharge. No landlord now can be. They do. They have to recalculate the MCI, the maximum 2%. That is absolutely true. And if they're charging more, that would be an overcharge.
Okay, one more question. If a landlord got to increase the rent by more than $65 to replace the windows after 30 years, the windows needed repairs, is the landlord responsible to repair?
Yes, the landlord is responsible to cure any and all housing maintenance code violations.